My mother has never been the type to ask for help. That's the first thing you have to understand about her. 73 years old, sharp as a tack, lives alone in the house she and my father bought in 1987, the house where I grew up, where my kids learned to walk, where she still grows tomatoes every summer in the side yard, even though her knees have been complaining since Obama's second term. She shovels her own driveway. She files her own taxes. When her furnace died 2 winters ago, she called the repair company herself, negotiated the price down $40, and didn't mention it to me until Easter. That's just who she is. So when she called me in early September of 2022 and told me the HOA had sent her a violation notice, my first reaction wasn't alarm, it was almost amusement, because I genuinely could not picture my mother being out of compliance with anything. The woman irons her dish towels. The notice said her mailbox post was the wrong shade of brown, not the wrong color, the wrong shade. Apparently, the community standards document specified colonial walnut, and my mother's post, which had been in that exact spot for 11 years, was closer to what they were now calling rustic chestnut. She called me half laughing about it. We talked for 20 minutes, and I told her to just paint it and move on. She said she would. I thought that was the end of it. It wasn't anywhere close to the beginning. 3 weeks later, she got a second notice. This time, it was about her driveway, specifically a hairline crack near the left edge that she apparently had the obligation to repair within 30 days or face a fine of $50 per day. She called me again, this time not laughing. The crack was tiny. She sent me a photo. I'm not exaggerating when I say I've seen worse on brand new driveways. But fine, rules are rules. She got quotes from 2 contractors. The cheaper one couldn't come for 6 weeks. The other wanted $1,200 for a job any reasonable person would value at $300. She was stuck. And here's where I made my first mistake. I told her to write back to the HOA explaining the delay and asking for an extension. I thought that was the sensible thing to do. I thought a reasonable organization would respond to a reasonable request. The extension was denied. Not just denied, ignored. She sent the letter by certified mail. No response. Fines started accruing. By November, she had racked up over $1,000 in fines for a crack I could cover with my palm. She called me, and her voice had something in it I'd never quite heard before. Not panic, more like a controlled disbelief, the way you sound when something is so absurd you keep waiting for it to correct itself. I drove out to see her that weekend. We sat at her kitchen table and I went through all her paperwork, the notices, her letter, the certified mail receipt, all of it, and something started to bother me that I couldn't quite name yet. The notices were all signed by the same name, Board President, Hargrove Estates Homeowners Association, a man named Gerald Pitts. I didn't know that name meant anything yet. That would take a while. My mother hired a property management attorney in January, a woman named Dana Kessler, who had a small office about 12 miles away and who came highly recommended by a neighbor. Dana looked at everything and said calmly but seriously that the fines were likely enforceable under the CC&Rs my mother had agreed to when she bought the house. The crack needed to be fixed, the fines probably needed to be negotiated down, but there was no guarantee. She could fight it, but fighting it would cost more than paying it. My mother paid the attorney $350 for that assessment and thanked her politely, and then called me afterward and said quietly, "Jarvis, I am not paying those fines." I believed her. I also didn't fully understand what that meant yet. We got the driveway repaired in February once the weather allowed. My mother paid $1,100 to a contractor who showed up, spread some compound, sealed it, and was done in 4 hours. The crack was gone. She notified the HOA in writing. She assumed, reasonably, that this would be the end of active enforcement and that we could now focus on negotiating the accrued fines down through whatever process existed. Instead, she got a new violation notice in March. This one was about a storage bin she kept on her back patio, a resin weather box, the kind you get at any home improvement store, where she kept gardening tools. It had been there for 8 years.
The notice said it was visible from the common easement pathway and violated Section 7, Paragraph 3 of the Community Standards document, which prohibited unsightly storage containers in areas visible from shared spaces. My mother went outside, stood on the pathway herself, and confirmed you could not see the box from the pathway without walking 12 feet off the designated path and craning your neck around a rose bush. She documented it. She took photographs with timestamps. She included a hand-drawn diagram with measurements. She mailed it all to Gerald Pitts. 2 weeks later, she received a letter informing her the violation stood and that fines would continue from the original notice date, $60 per day. That's when I stopped thinking of this as an annoying administrative dispute and started thinking of it as something else. Because taken individually, each notice had some technical basis you could argue, but the pattern, the speed of escalation, the refusal to consider documentation, the complete absence of any good faith engagement, that wasn't bureaucratic incompetence, that felt like something with a direction to it.
I drove out again in April, and this time I asked my mother something I hadn't thought to ask before. I asked her if she knew Gerald Pitts personally, if there had ever been any kind of dispute, any disagreement, any history between them. She was quiet for a moment, longer than I expected. Then she told me that about 3 years earlier, before any of this started, Gerald Pitts had approached her about purchasing a strip of land along the eastern edge of her property, a narrow buffer about 8 feet wide that ran between her lot line and the HOA's designated green space. He'd been informal about it at first, friendly even, said it would clean up the boundary. She'd declined. She liked that strip. She'd planted a row of knockout roses along it that had taken years to establish. He'd come back twice more, each time a little less friendly. The third time, he implied that the HOA might take a closer look at compliance issues in her yard if the situation wasn't resolved cooperatively. She'd told him, politely, but without any ambiguity, that she wasn't interested and that she didn't appreciate what sounded like a veiled threat. He smiled and said she was misunderstanding him. That was 3.5 years before the first violation notice. I sat there at her kitchen table for a long time after she told me that. My mother watched me. She was calm in a way that had started to seem like something more than composure. She poured us both more coffee and set the pot down and said, "I didn't mention it because I thought it was settled. People like that usually move on." I asked her why she hadn't mentioned it to Dana Kessler. She said she hadn't thought it was relevant. She said she still wasn't sure it was. I thought it was extremely relevant. I also thought there was something my mother wasn't telling me, not because she was hiding it, but because she had a habit, built over decades, of waiting until she was certain before she said something out loud. I'd grown up watching her do that. She would sit with a thing, turn it over, examine it from every angle, and only speak when she was ready. I didn't push. I'd learned not to. We filed a formal complaint with the state's HOA regulatory office in May. Most states have one, and ours had a division that handled HOA governance disputes, including potential selective enforcement claims. The complaint took 6 weeks to be acknowledged. In the meantime, the fines kept accruing. My mother was now facing just over $4,000 in combined fines across the 3 violations, 2 of which she disputed entirely. The HOA's attorney sent a demand letter in June, 30 days to pay, or they would pursue a lien on the property.
A lien on my mother's home. I want you to sit with that for a second. A woman who had owned her home for 35 years, who had never missed a payment, who had maintained the property with a precision that would embarrass most people half her age, being threatened with a lien because of a storage bin that you couldn't see without trespassing into a rose bush. I called the attorney, a man named Patrick Holloway from a firm that did HOA work for several communities in our area. I told him about the land dispute. I told him about the timeline. I told him I believed this was retaliation and that the HOA was going to have a very difficult time explaining why a single elderly homeowner had received 6 violation notices in 9 months when the neighborhood association's own records would likely show far less enforcement activity across comparable violations in other properties. He was polite. He was also unmoved. He said the CCNRs were clear, the fines were valid, and his client had the legal authority to place a lien if the debt remained unpaid. Then he said something that stuck with me. He said, "Mr. Narrator, your mother should consider what this kind of protracted dispute costs a person, at her age especially." I didn't say anything for a moment. Then I asked him to repeat that. He softened it, said he just meant that legal disputes were stressful. I knew what he meant the first time. I called my mother that night and told her what he'd said. I was angry. She was quiet. Then she said, "Write it down, the exact words, date and time." Her voice had gone somewhere very specific, somewhere I vaguely recognized but couldn't quite place. The regulatory complaint hit a wall in August. Investigator assigned, preliminary review, no findings yet. These processes moved the way glaciers moved, and Gerald Pitts knew it. He'd done this before, or someone who knew this playbook had helped him. Then in September, almost exactly 1 year after that first mailbox notice, my mother sat me down at the kitchen table, the same coffee, and she told me what she'd been waiting to tell me. She had not always been retired. I knew she'd been a judge. She'd served on the circuit court for 22 years before retiring, family law mostly. I knew the broad outlines. What I did not know, what she now laid out for me with the same measured precision she'd apparently applied to 22 years of legal decisions, was that in the final 4 years of her tenure, she had presided over 2 cases involving HOA governance. One of them resulted in a ruling that significantly limited an HOA board's ability to selectively enforce CCNRs as a retaliatory mechanism. The ruling had been cited in subsequent cases across 3 counties. She had written the opinion herself. She slid a printed copy of it across the table. I read the first paragraph. Then I read it again. Then I looked up at her and said, "Mom, did you know this when you started getting the notices?" She said, "I suspected the foundation was the same. I wanted to be sure." I asked her what she meant by the foundation. She told me that Patrick Holloway, the HOA's attorney, had clerked for a firm that had been on the losing side of one of her rulings, a ruling that had cost that firm a significant client and, by extension, a significant amount of revenue. She'd recognized his name when the demand letter arrived. She hadn't said anything because she was still confirming the connection and because she'd wanted to see how far they were willing to go. "How far they were willing to go?" I repeated. "Yes," she said. "Now I know." I don't know exactly how to describe what the next 3 months looked like from the outside, because from the inside, it moved in a way that didn't feel like watching a legal dispute anymore. My mother retained a new attorney, not a property management attorney, a civil litigator named Robert Eccles, who, in a previous chapter of his career, had handled judicial ethics cases. He was 60 years old and wore suits that were slightly too large for him, and he had the quiet manner of someone who had never once felt the need to be louder than necessary. He filed a civil suit in October alleging selective enforcement, bad faith HOA governance, and intentional infliction of emotional distress. He also filed an amended complaint with the regulatory body that now included specific documentation of the prior land solicitation, a timeline showing the pattern of enforcement actions, comparative data showing that 4 other properties in Hargrove Estates had visible storage containers with 0 violation notices, and a section, very carefully worded, referencing the connection between the HOA's counsel and my mother's prior judicial rulings. Gerald Pitts resigned from the board in November. No statement, no explanation, just gone. The board, suddenly operating without its president and apparently aware for the first time of the specific legal landscape they were standing on, voted to waive all outstanding fines in December. Not reduce, waive, every dollar. They also agreed to reimburse my mother's legal fees up to a specified amount and to formally document in their meeting minutes that the violation notices related to the patio storage container had been issued in error.
Issued in error for a bin that a year ago was apparently serious enough to threaten a lien over. Patrick Holloway withdrew from the case and did not comment publicly. I looked him up 6 months later out of pure curiosity. He was no longer listed as affiliated with that firm. The regulatory investigation concluded in February with a finding that Hargrove Estates had demonstrated a pattern consistent with selective enforcement and issued a formal corrective action order requiring the board to implement documented, consistent enforcement procedures and submit to a compliance review in 12 months. My mother planted new roses along the eastern buffer strip last spring, pink ones, the kind that come back every year without being asked. I visited her in May, and we sat on her patio, right next to the storage bin which still holds her gardening tools in the exact same spot it always did, and I asked her something I'd been turning over for a while. I asked her if she had been scared at any point, during any of it. She thought about that seriously, the way she thought about everything. She said, "I was angry. Anger and fear can feel similar from the outside." She paused, but no, I wasn't scared. I've watched people use process as a weapon my whole career. I knew what this was. I just needed them to show me enough of it. She picked up her coffee. "The lien threat," she said. "That was when I knew we had everything we needed. Nobody threatens a 73-year-old woman's home over a garden box unless they're not thinking clearly. And people who aren't thinking clearly make mistakes." She looked out at the roses. Gerald made quite a few. I drove home that evening thinking about a version of this story where my mother was someone else, someone who didn't have 22 years on the circuit court, someone who didn't know what selective enforcement looked like from the inside, who didn't recognize a clerk's name on a demand letter, who didn't have the composure to sit quietly for a year while building a record. What happens to that person? They pay the fines, they live with the threat, they sell the strip of land, they move out eventually, probably, because it never really starts once it starts. That's what gets me. Not that my mother won. She was always going to find a way through. She was always going to be the most patient person in any room that Gerald Pitts walked into. What gets me is that the whole apparatus, the notices and the fines and the attorneys and the lien threats, all of it was built on the assumption that she wouldn't be. They picked the wrong house. They just had absolutely no idea how wrong.